Good afternoon. And keep eating because we need to, we start these on time so that we have plenty of time to discuss juries and jury trials and how to improve them and can adjourn promptly at 1:30. So if you have not finished eating, continue eating. Please go get more food, get dessert, and we will start the program. I'm Steve Sussman, the Executive Director of the Civil Jury Project at NYU School of Law. And I want to begin by thanking our sponsoring organizations, which are listed on the screen, and the law firms that have agreed to serve as our host. So the Civil Jury Project is the only academic center in the country that is asking the question, why are jury trials, well, we began by asking the question, are jury trials disappearing? We answered that in about a day, and the answer is yes. And the next question is, why is this happening? Do we care that it's happening? And if so, what can we do about it? It is strange that, except for the attention that some bar organizations, trial lawyers associations particularly, on both sides of the V, except for the attention they give to the issue, no one seems to be very concerned about the disappearance of jury trials in this country. And I hasten to add, I'm going to show you some statistics in a second that show that what's happening is all public dispute resolution, other than cases are being filed, but they are not being disposed of either by trial, either jury or bench trial. Indeed, bench trials have gone down quicker in this country than jury trials, something we did not know when we began the Civil Jury Project. Maybe we would have called it the Trial Project. People are opting for private dispute resolution or being forced to go to private dispute resolution. And unless we do something to reverse the trend, public dispute resolution is going to become obsolete. It's strange that the jury trial was, we tell people that it is the only right that's mentioned 5 times in our founding documents, in the Declaration of Independence, in the Constitution itself, and in 3 of the Bill of Rights. In the Madison Papers, plus all the history we have read about what went on in Philadelphia when the Constitution was enacted and when the Bill of Rights was subsequently passed. Everything indicates that the founders were keenly aware of the need for juries to protect other rights that were bestowed by the Bill of Rights. One of the reasons that our founding fathers revolted from the king was that he was denying them the right to trial by jury. And they viewed very clearly, and there was no, they were quite frank about it. The anti-federalists, particularly the southern states, were very candid about acknowledging that jury trials are going to be more expensive, more complicated. Juries are more prone to eloquent advocacy, and they're going to take longer, but we still want them. And we want them because juries will protect the little guy from big corporations, debtors from creditors, and powerless people from judges appointed by the monarch or the chief executive or whomever is appointing judges. And they went into that with their eyes wide open. Yet today, jury trials are in decline. And it was with, I had been involved personally. I've been trying jury cases for over 50 years. So it was I've tried to do my work for the American Board of Trial Advocacy, ABOTA, as co-chair of the Save Our Juries Committee. And what I learned very quickly was that bar associations are incapable of sustained effort to change anything, particularly what happens in the courthouse. And it's understandable. The lawyers meet 3 times a year in exotic places. They're thinking Friday for an hour or two during their committee meetings about what can be done to save jury trials. And then Saturday, they're thinking about their tea time. And Sunday, about their flight home and what they have on their schedule for the next week. And we don't see them again for 4 or 6 months until the next meeting in some beautiful place takes place. So it was with that idea that we set up this project, got the law school at NYU to set up this project. And with the help of our research fellows, who Stan Richard Jolly and Anna Offit, who are two wonderful, Anna, stand up so people see you, and Caitlin Villanueva, who's at the front desk. This is my staff that helps me with all this. We have done a lot in the last 3 years. We have created 2 websites, the first of which is Civil Jury Project at Law NYU Ed. And this is something that has tremendous material on it for lawyers, judges, and academics. One of the things we did first is, instead of going to bar associations and getting trial lawyers involved, we went to the judges themselves. We now have over 250 judicial advisors, state and federal trial judges around the country. We have 3 of our federal court advisors are here in Maryland, and we have state court advisors who are here also. Judge Geller and Judge Carrion are our state court advisors from the city court, and we, of course, this is a non-exclusive list. We are looking to add judges who are interested in the subject all the time, which simply means we have people we can talk to. They share with us their email addresses, and they give us feedback on what they are doing. We also have academic advisors, about 60 law professors around the country who have written or done empirical research on jury trials and how they decide cases. And finally, and this is never done before, I don't think, we have created an alliance, and we have jury consultant advisors, an alliance between us and the American Society of Trial Consultants. We have over 35 jury consultants around the country, and they are able to test some of the innovations with actual juries or mock juries. Our projects, in addition to empirical research that we're doing, is we have a newsletter that is published monthly, and we're doing that for more than a year. We have been conducting these jury improvement lunches around the country. This is our 13th such lunch. We have one on Thursday in Cleveland, Friday in Columbus, by the end of, and we have them scheduled for Philadelphia, Los Angeles, Boise, Idaho, Miami, and Las Vegas. So the lunches have been typically extremely successful. We get a lot of judges and a lot of jurors. We normally get more lawyers attending than we do here, and I suspect that's because most states have a CLE requirement, and people are anxious to come out and get CLE. And so this is a barrier to entry we have in the Baltimore market. I mean, the judges seem to be interested as judicial advisors, but it's been very difficult to engage the bar. And the notion of doing these things is that we will, if they're fun and useful, the local bar, the local lawyers will create a planning committee and do another one a year from now, or either annually or semi-annually, whenever they want to do it. In May, we are having our 4th in Houston, our 3rd in Dallas, and in June we have our 2nd one in Seattle. So it's beginning now. We're on the situation. And what we find, frankly, is that first, we owe it to the jurors who have served to ask them to share with us their knowledge. Jury service is the only duty that the Constitution demands of the citizens. You don't have to, we have a volunteer army now. You only have to pay taxes if there's a law passed that requires that you pay taxes, but people have got to serve on juries. It's a duty. It's the only duty we have as citizens today. You don't have to vote, but you do have to serve on a duty, on a jury, and vote on a jury. And those who, we have not paid enough attention to those who have given their time. And what we have found when we do pay attention to them is that they have great ideas for improving the system, and, although most of them, the vast majority, had a wonderful time serving on the jury and would do it again. We've had workshops for judges. We bring 30 judges at a time to the NYU Law campus, and we have a full-day workshop for state judges and federal judges from around the country. Judge Garbus, who's supposed to be here but has a jury trial going on right now, will be here shortly, I hope, and say a few words. He attended one of these judicial workshops, and Judge Carrion and Judge Geller did a few weeks ago. So they've seen what we are trying to do and how we are trying to educate the bench on jury trials. If you want to look at our newsletters or on our website, a second website we maintain is something called WeThePeopleWeTheJury.com. It's up and running. It gets tremendous traffic. And the point of this is to give people who have served on juries somewhere they can go and blog about the experience, essentially. If you have served on a jury, you click this icon and you're taken to a questionnaire. And the questionnaire asks you all kinds of things about your service, what can be done to improve jury service. And one of the questions are, we ask, and we get jurors to go to that site by asking our state and federal judges around the country to hand to juries who are discharged a little business card that says, make your voice heard. By sitting on a jury, you have provided tremendous service to your community and country. We're doing this. Go and anonymously talk about your experience at We the People, We the Jury. We warn all our jurors when they get to this site. We warn the jurors who are here today, and I'll introduce them in a few minutes, that it is important that they do not talk about their deliberations. We do not want to know about what they thought about the judge or what they thought about the lawyers or what came up during the deliberations or the facts of a particular case, because there may be some pretrial motions going on or something, someone looking for some excuse for jury misconduct, and we don't want the source of knowledge jurors have to be shut off because they have created some problem that will lead to post-verdict motions to set aside the verdict because of some sort of jury misbehavior. We've not had that instruction violated ever, either at one of our lunches or on the questionnaires we compile. We have a lot of people going to that. We also have a lot of people, well, when they go to this icon, currently serving on jury duty, they're told you shouldn't be here. The judges tell you shouldn't be here. Come back when you're finished, okay? And when they go to this icon, receive the jury summons. What they discover what we discover is that most of the people who surf the web using the words jury or Twitter using jury are people have received a summons and want to find out a way to get out of it. That's what we are finding. And we have figured out that if we send them to this, they go right there, receive a jury summons, and when they tell us why they came there, that is to get out. How do I get out of it? But they are met immediately by several judges and by many of the people who served on jury duty who we have video testimonials from. And if you want to learn about how nice jury service is, just go to this site and click on Receive a Jury Summons, and you will see marvelous laudatory remarks about jury service and telling people, don't throw away your summons, go do it. It'll be the best thing you've ever done. It's exciting. I'd love to do it again. And so, and we get people, how we get people there is we have an active presence on social media with a lot of followers, and we kind of send them through the Seventh Amendment. We ask them to go there. we the people, we the jury, and that's what they find on the social media, and they go to that site. We have now what's today our focus here is on how we can deal with the phenomena, which is highlighted by this next slide. The federal statistics are readily available to us. The state ones are not, although the state court judges who are here today may have some ideas of where we can get those. And it is clear in federal court, though, and the data goes back to 1962, and the red dots, red squares, are percentage of cases disposed of by jury trial. Obviously, that's the important thing to look at, because the number itself of jury trials would be determined by the number of cases filed, and the number of cases filed goes up and down. But the percentage of cases filed that are terminated by trial or terminated otherwise, by being sent to arbitration or by being dismissed on the pleadings or by being dismissed with prejudice on a summary judgment motion, those account for the other dispositions today. But you can see under 1% of the cases are disposed of by jury trials in federal court last year, and you can see the blue line is bench trials. It exhibits the same pattern. So those people, by the way, one of the first things you hear people say is, well, the reason jury trials are disappearing is that they're too expensive, or that the result of a jury trial is too unpredictable and uncertain, or that it takes too long to get to trial. All those things are accounted for they are present with a bench trial too. So how do you explain, bench trials are, in everyone's experience, equally as expensive, can take the same amount of time as a jury trial, if not more, because there's stops and starts. The same discovery goes on in a bench trial, and yet the theory that judges are more predictable than juries is not played out in these figures. The average number of trials per federal judge, jury trials, last year was under 4, and the average number of bench trials was just slightly over 1. In the District Court of Maryland, the federal court figures, the same pattern exists, although it goes up and down a little. But the average judge in Maryland, this is the total number of trials, and if you look at, again, the trials per judge, in 2016 there were 21 jury trials, meaning 2.1 per authorized federal judgeship. There were 19 bench trials, or 1.9 per authorized federal judgeship, and the numbers, these numbers are above average because we have up here Colorado was a slide we used in Colorado.
My apologies, Steve. Those aren't the correct. Those rankings are correct. I wrote Colorado as opposed to Maryland. My apologies.
Okay, they are for Maryland.
Those are for Maryland. Those numbers are for Maryland.
Okay, and so you rank the 28th in the country with the most jury trials per judge, and 7th for the most bench trials per judge. The state court figures almost everywhere are the same as the federal figures. They follow them. There is something we have learned goes on in your Baltimore City Court, which is a central docket that may account for maybe more trials here than elsewhere, probably a number, but I suspect that the trend, from a historical trend, has been on a downward path, which is why we are here. We have one of the studies I'll talk to you, just very briefly talk to you about 2 of our studies. One of them was a study of major corporations, big business contracts, the material contracts that they file with the SEC, and they're attached as exhibits to their 8Ks and available for public inspection. We reviewed contracts for a 6-month period last year and discovered we were looking for which of the contracts contained jury waiver clauses or mandatory arbitration clauses, which have the same effect of avoiding a jury trial. And we found, to our surprise, that only about 43% of the contracts we looked at had such clauses, meaning the majority of contracts, hopefully the majority of general counsel and corporations, still have faith that in the jury as the dispute resolution mechanism of disputes between them and equally powerful negotiators, arm-to-arm negotiation. Another study, and so we are calling those general counsel and asking them, did you just forget, or was this intentional, or why do you really prefer jury trials over some other form of dispute resolution? We're getting tremendous testimonials from general counsel saying that they don't like arbitration anymore. It's gotten too expensive. It takes just as long. Discovery is just as abusive. The arbitrators typically split the baby, and they have no interest when they're paid $750 an hour to be judges to have the case end quickly. And those kind of comments coming from the general counsel, the former general counsel of Exxon, so I think are interesting, and we are trying to put together testimonials from general counsel about the advantages of jury trials. And one of the biggest things they don't like about arbitration is it's non-appealable, whereas anything a court does is appealable. The second study we did was to ask more than several thousand people in a non-lawyers whether they thought that jury trials were declining or trials were declining, and the vast majority, about 80%, thought the trials were either going on the upswing or remained the same over the last 10 years. Totally wrong. Trials everywhere are declining. When we told people that and asked them whether they were concerned that jury trials might be disappearing or decreasing, initially they weren't concerned, but when we told them it was a constitutional right, they were very concerned. So part of our job is to educate the public on what is happening at the courthouses and what the source is of their right both to have a jury decide their dispute and their right to serve on a jury. I want to recognize now the judges who are who are here. Judge Carrion from the state court, Judge Carrion's in the back. She was at our conference in New York a few weeks ago. Judge Karen Friedman is here. She's up at the front. We kind of try to mix up the judges so they are sitting with the lawyers. Judge Geller is here. Judge Monroe, the jury commissioner, is here. There you go. And now I'd like to call upon Judge Hurd, the chief judge of the Baltimore City Court, to make a few remarks and welcome you to this event. And we'll put Judge Garbus on if he arrives. I haven't seen him come in yet.
I'll be very brief. First, I want to welcome you to Baltimore City for those of you that are visiting from points north, and thank the Civil Jury Project for the NYU Law for coming to Baltimore. And this is, from what I understand, Jury Appreciation Week. So our timing is perfect for a celebration of those of you that are present that are jurors. Baltimore City is one of the busiest urban cities, and we are in the state of Maryland, the busiest court. Recently we had a state of the courts, and our administrative judge, Pearson, announced that last year we had over 500 jury trials at the Circuit Court for Baltimore City with 35 judges. We don't see a decrease, but as you said, we may be an exception to the rule. You've already acknowledged my colleagues who found a little time to come here, but I'm sure they would agree that we stay very busy on a daily basis, both on our criminal and our civil dockets. We continue to bring in jurors daily, anywhere, as the commissioner would attest, from 600 to 800 jurors every day. And as our dockets require, sometimes we have to bring in more jurors in order to accommodate the trials that we have on our docket for any given day. Again, I just want to welcome you here today. I think we must honor our jurors and jury duty. All of the judges have to serve, as well as the lawyers have to serve. And it's often forgotten that we could not do what we do unless jurors came forward. As you all know, it's a one-day or one jury trial, but every now and then our jury trials do last for several weeks. And in order to have citizens of this city and across the state to come and volunteer their time to sit and sort of turn on end their work and their home life, we must continue to encourage them to participate. It is a civil duty, like you've heard it said, but it's not like no other. To be a part of the system is really what I try to encourage when jurors seemingly try to get out of jury duty. I like to remind them that if they're not in the room helping make a decision, then they can't call the process unfair or unequal. And in that way, I encourage them to be part of our judicial system. If they see errors in it, if they see justice failing, my first question is, did you serve on jury duty? And if their answer is no, then I say, how can you complain if you haven't been there to see justice done? I want to thank you all and have a wonderful afternoon.
And now for the program, and let me introduce and ask them to come up and they've agreed. We have 5 jurors with us, 4 of whom are going to be on the panel, and Judge Juror Howard, Walter Howard. Mr. Howard, would you come forward and sit where? Seat is?
Beside you.
Thank you. We have Andrea Scott, Christina Welty, and Melody White. And I also want to recognize she's not going to be on the panel, Robin Ryder. Robin, are you here? Yep. No, Robin. Would you like to be on the panel? Yes. Oh, come right ahead. We don't have you. We tried to get everyone's permission. Please come ahead. And do we?
You need some water, right?
Yeah, and we need Judge Geller is going to come forward. And we're going to give you another seat. Richard, hang on, we're going to give you another seat. Thank you.
It's heavy, huh? Oh, sorry.
Huh? Mr. Ryder, did you serve on a jury?
Not this year, but years before.
Okay,
It's
well,
been a
just
learning experience. Oh.
have a seat and we'll get to you.
Okay.
Sure.
They closed right because of they shut the courthouse early.
All right, well, we want to thank the jurors who came here and are willing to share their experiences with us. Now, let me ask the first question. Was your jury service, was all of your jury service on state court, or did someone serve on a federal court jury? Everyone state court?
State court.
State.
State. And I think we have some people who were served on civil jury. Who served on a civil jury? Anyone served on a civil jury? So all of these jurors have served on a criminal jury.
Yes.
And while this is the civil,
Steve, you got to turn your lapel mic on.
oh, excuse me.
Oh, what? Here's a little bit of light. You just had to turn on it.
What we have, let me turn this off because you don't need to be looking at that. Okay. What we have, why we got criminal jurors to come, it wasn't in lieu of civil jurors. There's just more criminal trials going on, more jurors available to us. From the juror's perspective, a criminal trial and civil trial are very similar. The reason we have limited the work of the project to criminal trials, to civil trials, is that the reasons why criminal trials are declining, and they look similar to the graphs of civil trials that you've seen, bench and a jury. The reason criminal trials are going down are different than the reason civil trials are going down. Criminal trials are going down because of the sentencing guidelines in many jurisdictions, where the jeopardy of going to trial makes people want to settle by entering into a plea, as best we can tell. But that's not strictly, but the experience of a jury is very much the same. Did the juries you've served on return a verdict?
Yes.
Yes.
Okay, let me just begin with you, Mr. Howard. How long was your trial?
We started on a Friday and we were done on Monday afternoon.
And with deliberations and everything?
Yes,
And how did you like the experience?
very much.
Would you do it again?
Absolutely.
What did you learn that what did you learn from the experience?
Well, I was refreshed on the rules of the operation, and what I learned was that in the city of Baltimore, from 12 different backgrounds, different ethnicities, different religions, placed in that situation, the civility of it blossomed, and we 12 people were able to communicate in a way we wouldn't have ever thought of doing on the street. And so I learned that my neighbors and fellow city dwellers are as beautiful as I thought they might be.
The deliberation part of jury duty is something that everyone says is magical. The need to get together in a room and decide something. I'll tell you all a story that happened to me last Thursday night. I was at the TED conference. You've heard the TED Talks that you hear on the radio and see on TV. I was at the TED conference in Vancouver, and they asked me to do a dinner party inviting TED attendees to discuss jury trials, discuss the same things we were talking, but these were non-lawyers. A few had served on juries, most did not. They were a lot of people were from executives in Silicon Valley. And we went around the table, and the question I began with to everyone, if your property or freedom were at stake, would you want to be tried by a judge, an arbitrator, or a jury? And that's the way we began this conversation going around the table. And, you know, there was a mix. Some people said they preferred a judge. Some people said it depended on what the case was about. And obviously, all of them said it depended on who the judge was, because you do not know in advance of who the judge is going to be. There's some judges you'd be happy to try your case, whatever it might be. Others you would not be happy. But a jury is more of a cross-section of the community. And then we turn to the next question you're supposed to, it's a single conversation. You've got to keep going, 12 people around the table. There were 12 of us. That's the maximum number. And the next question was, well, should the right to civil jury trials be guaranteed? And I pointed out to them that the United States is the only country in the world that guarantees people who have a civil dispute the right to take their civil dispute to juries. Criminals, different. Criminal cases are different. But the United States is unique in guaranteeing the right to civil jury trials. And then we began going around the table, and I said, let's assume we were called upon as this group of 12 to write a new constitution for a new democracy, a new country. Would we enshrine in the Constitution the right to trial by jury in civil cases, or is that kind of like the wig, that lawyers used to wear? Kind of cute, but obsolete, given the current way we live. And so we began talking about that, and then it was obvious there were some people there were three. I decided, totally extemporaneous, to say, why don't we deliberate like a jury here? There are 12 of us. So we will deliberate on this subject. Beginning now, we will deliberate to a unanimous verdict, and no one goes home until we get a unanimous verdict. I'll be the foreman, and it was the most brilliant idea I've ever come up with, because in causing these people to deliberate, 12, and to argue with each other and to listen to each other, you saw the magic of deliberation. Ms. White, how about you? What kind of, how long were you on a case for?
My case was from, we got picked on Monday, so it was from Tuesday to Friday.
And did your jury return a verdict?
Yes.
Okay. And how long did the deliberations last?
We started Thursday evening about 3, and we ended Friday evening about 5.
Wow.
And overall, was it a rewarding experience for you?
It was rewarding and emotionally driven.
And what?
Emotionally driven.
Okay. And Ms. Welty, how about your experience?
Okay, what was the first question?
Hmm?
How long was it?
Yes.
Okay, we started on Tuesday afternoon and we finished on Monday morning, so the actual time was about 4 days.
And you were they returned a verdict in your case
Yes,
too,
I was afraid we weren't going to. We did.
but they reached a verdict. And
Yes.
was is it an experience you would like to repeat?
Yes, I would, yeah.
And Ms. Scott?
I was on the same jury as my friend down at the end, Harold, and that was the same amount of time from Friday until Monday. And Judge Geller was kind enough to let us know how long it was going to be, which was very helpful. And he made the experience very positive. And as a juror, I would have to agree with what he said, what Harold said in terms of communication with our peers. And it was interesting, the different inputs that the different ethnic groups had, and people from different parts of the city and different walks of life. So you got to see a different opinion from each person, and then we had to come together and figure out, we voted, and then it was 6 and 6. So then we went around the room and we kind of stated our case. And as I was telling many of the people that had not been on a jury, they didn't quite understand what it was that they were supposed to decide on. Not whether or not the person was guilty, but whether the state had proven that they were guilty. So that took quite a while.
Yes.
But
The burden of proof.
I enjoyed it.
Yes.
The burden of proof instruction.
Yes.
Yes.
I'll get to instructions in a little while, and let me ask you this question. When you came to the courthouse, your trial took place when? Recently? How recently?
Yeah, it was just a month ago.
Uh-huh.
Month ago?
It's fresh.
When you show up at the courthouse and you go to the jury assembly room, who does a person greet you? Does a judge come down and talk to you? Is there a movie? What goes on in the jury assembly room?
Oh, you're asking me?
Yeah.
Oh, you go in and then you sit in this room and you bring a lot of reading material and other things, so you're not bored. And then they call you up and they give you money. And then you go back and you sit down and you read some more and maybe you talk and then you wait for them to call you your number, and then you follow the person who's walking too quickly across the street and up the steps and in the elevator, and some people get
There is
lost.
a video.
And that in itself is quite the experience.
Can anything be done to improve that experience? Do you find that there's...
In
do
all
you-
fairness, there is a video that presents the duty to you in a televised fashion on a flat screen in a comfortable waiting room. So you are immediately educated to what you're there for, and it's a little inspiring.
But not great. It could be improved.
It might be better.
That's one of the things we're thinking about doing, is trying to really get what happens in many of the jury rooms is that the judges insist on doing it. I mean, they're the ones who appear in the movie. I don't know whether they appear in your movie, but judges are not exactly movie stars. And so the idea is we could create a film that would be great with the history of jury duty, They could be shown in jury assembly rooms around the country. How long did it take before you were called out to a courtroom?
2 hours.
Ms. White, you?
About an hour or less for me.
Yours was an hour or less. How long did
About,
you?
about noon, so we got there about noon, about 4 hours.
And then you went to courtroom.
Correct.
And then the jury selection process begins. And during the jury selection process do they allow the lawyers to participate in that process in state court here in a criminal case or not?
A little
Judge
bit.
Giller?
It varies judge to judge as to how much we'll allow the lawyers leeway to ask questions. Some judges won't allow the lawyers to ask anything unless it's pre-approved. They'll have each juror step away and pre-approve questions. I'll ask all the follow-ups that I think the lawyers might be interested in knowing, and then I'll ask each lawyer if they have additional questions. But compared to other jurisdictions, especially after being at NYU, we really have limited voir dire, and based on the case law that we have on voir dire.
It's not allowed, or?
Our case law is very specific that Maryland employs limited voir dire. It is not intended for the intelligent exercise of peremptory challenges. It's only to find specific cause for disqualification.
Even in state court, even in civil cases?
Even in civil cases.
Okay. And did any of the jurors in these have to fill out questionnaires of any kind, written questionnaires?
We didn't. I think, well, they have the basic questionnaire of general qualification to make sure that they still are a city resident, appropriate age, not excluded by conviction, but they do that in advance of coming to jury service. There's no long form questionnaire unless, some lawyers will, in civil cases, may agree to a questionnaire. I haven't had that experience in the 2 years I was in the civil docket.
Do your verdict, you have 12 people on a criminal jury, and the jury had to be unanimous.
Correct.
And how is the foreman selected?
So different judges do it differently. I know a lot of judges will just say the person who's sitting in first seat number 1. I don't do that. I've found I had some looks of horror when I've done that from the juror number 1. So my pre-deliberation instruction to the jury is I tell them that their first order of business when they go back to the jury room is to select a foreperson. You can volunteer, you can have a vote, and I explain to them what the foreperson's job is, just basically to organize the discussion, take the vote, and ultimately announce the verdict. And I found that, and it's interesting because you never know who's going to pop up to announce the verdict. And sometimes my law clerk and I will talk, well, who do you think the foreperson's going to be?
Yes, the empirical research that has been done by some of our academic advisors has found that the foreperson of a jury plays a oversized role in deliberations. That basically, in a close case, the foreperson has a big influence. Did y'all find that at all? Your case may not have been at all close.
It's a funny story, actually, because our jury was so balanced in terms of women and men and African Americans and Caucasians, and just everybody was there. The lady who was in position number 1 was uniquely qualified to be the foreperson because she was outspoken and she was strong, and she refused to do it. And I volunteered because I'm the junior warden of the church and the president of the homeowners association, and I'm on several boards, and I know how to do this sort of thing.
Say.
And then as soon as we started deliberating, everybody wanted to participate and do that role. And in many respects, she did end up guiding our deliberations and urging us to the decision. I was just there to appear in that position.
Interesting. Well, but the fact that you got the job probably is evidence of what the academics have found, that the foreperson does have a pretty big role in the
It did seem to work.
deliberations. Yeah, it worked in your case. when the case actually begins, did you think the lawyers were kind of evenly matched, or do you think there was a mismatch? Ms. Scott?
Not at all. I thought the the individual that represented the state, as long as I could keep my eyes open and my ears listening, it was a good thing because he just had no force. He was boring, and was not engaging. Where the other attorney, she used right. That's correct, right? And so in your ear, you listen to what she's saying, and she was very cognizant of the things that people would listen to. And she was very visual, she moved around, she was very engaging because it's hot in there and you could fall asleep. In fact, one of the jurors did fall asleep. So she definitely engaged us, and she was much more convincing.
All right, and and was that reflected in the verdict? I mean, did her side win?
Yes.
Okay, how about in the case you were in, Ms. White? Were the lawyers evenly matched, or did the better lawyer win? Or was there a better lawyer?
The better lawyer won, but the prosecution, we had two. So one just wasn't up to par. She wasn't believable. So we kept, when we were deliberating, we just kept being like, what is she talking about? And it seemed like it took forever to get to a point. Like they kept stretching out what could have been said in like a day. Like it was like forever about the same thing. And we kept saying like, what is going on? Like I thought at the end we'd get like the bam, like they would come out and do like boom, this is what, and it wasn't. It was kind of like, when is this gonna be over? Like we couldn't talk, of course, but when we were able to deliberate, we were like, she talked for 4 hours about nothing. It was about like nothing that could have been said in like 20 minutes.
Ms. Welty?
I think the lawyers were pretty well matched, although there were things during deliberation that we felt like were glaring gaps for both of them. Oh, if that lawyer had this or this, and maybe one of the jurors had some knowledge of what is possible, say technologically or whatever, then if they had this proof, which they could have easily acquired, then we would have convicted the person of that count. But we didn't. So that happened on both sides.
So again, and I don't know how this question may, all jurors, criminal or civil, complain about repetition. It's the one consistent thing we hear complaints about. Lawyers are repeating themselves. And of course, as a lawyer, one of the reasons I do that is you're taught that the way you teach someone is you repeat it, whether from a dog or a cat or whoever you're trying to teach something as a teacher. Repetition is important. The problem, the difference between a trial lawyer and a school teacher is we have no way of knowing whether you're getting it.
Correct.
Because certainly in criminal cases, there are very few courts that will allow jurors to ask questions. One of the innovations we have suggested that's now being used widely in civil cases around the country, and I would say the adoption rate is probably 50% of the judges, maybe it's 40%, but it is a substantial number of judges, regardless of the jurisdiction in civil cases, are allowing the lawyers to submit questions in writing to the jurors. I mean, it's done in a way that would not offend you all. One gets a piece of paper, and the bailiff picks up the piece of paper and hands them to the judge. You don't have to write anything on it. Your name's never put on it. And the judge will look at the questions, and the ones that are appropriate, he or she will give to the lawyer and say, this looks okay to me. And what we have found, that is an innovation that has been used because It one of the advantages is that it does let the lawyers know right away they're getting through, or they aren't getting through, or they missed something. What would you have thought about having had the opportunity to, and I don't mean to ignore you, to have asked, what would you have thought to have had the opportunity
I
to
would like that, yeah.
ask questions?
Yes, I would.
It would have
It would, yeah.
helped you.
Yes.
Anyone else have any feeling of that?
Would you have wanted to ask questions of the witnesses that that you felt the lawyers missed?
I think several people would have, but I wonder where you draw the line. And so we understood why it had to work a certain way.
Well, the judge instructs the jurors at the
Correct.
beginning of the case that there are questions that you may submit in writing that I'm not going to ask or let the lawyers ask, because the law makes it totally irrelevant what the answer is, and you know, don't worry if your question is not asked. But the truth of the matter is that in most cases I've been in where questions are asked, they're really great questions. They're terrific questions. Juries are very insightful. And one of the things we are doing as we go around the country is to find out about these practices that are being adopted in jury trials to make it better. One of the practices that I did not talk about is each of you, in your case, you had an opening statement from both lawyers
Yes.
before the case began.
Yes.
Some judges now are requiring the lawyers to make those opening statements in front of the entire venire. In other words, the 50 or 60 people that went to the courtroom with you for jury selection, they get it before the questioning begins by the judge. So, you know, yes, you have to listen to something in a case you may not be selected to serve on. But the lawyers spend the same amount of time whether they give the opening statement the first thing Monday morning or the first thing Tuesday morning or the first thing Monday afternoon after the jury is seated in the box. But there's an innovation, and in what we've found is that in almost all the innovations we are suggesting, and they are on our website, there are about 14 or 15 of them. They're nothing new. They're all really basically suggested by the ABA has a jury commission, American Bar Association has a jury commission. These things are all suggested even by many organizations, but that is one. Questions, they all suggest that questions be allowed. Another thing, and so the judge did tell you exactly how long the trial would last, right?
Yes.
That was good.
Yes.
Because,
Good job.
and the only way, and it's interesting because the only way the judge can do that in a way with juries is to set the time limits himself, but ask the parties how much time it's going to take and then tell you what it is. You had all very short trials. A lot of the complaints we get about jury service are people have to serve for weeks, which, I mean, you're lucky you had a short 4-day, 5-day trial. But some people serve for weeks or months in trials, and they want to know when it's going to end. But you were lucky that you were in shorter trials. Another thing that people have talked about is, why don't we, the judge instructed you, all of you, that you're not to talk about the case until you deliberate at the end, when everyone's present, and you've heard all the evidence. Some scholars have suggested that that's stupid. People don't learn that way. When you are in school, you're not only able to ask your teacher or professor questions, but you're allowed to discuss the lecture. You don't have to wait till the final exam to discuss it during the final exam with your fellow students. I mean, you're allowed to talk after every lecture about, oh, that was a horrible lecture. That professor did a great job. But so the suggestion has been made that we should allow jurors, when they are together in the jury room, to discuss what they heard, as long as they don't decide the case. They cannot vote.
Correct.
And there are pros and cons to that. but I bet there is a temptation to want to say, comment at least to your fellow jurors. I didn't. That was a horrible witness. She could remember nothing. You know, why did they call this witness? Yes, ma'am.
Well, one thing that would be helpful with is there's so much information that's coming at us as jurors, and even if you take notes, you can't catch everything. And to be able to ask, did that witness say something about this particular issue, or did I miss it? To be able to do that ahead of time and know that that's an issue that was already that has been covered. You know, it just would be helpful during the trial. Rather
Yes,
than
to either-
have to wait till the end.
Right, not have, and you could even do that in the questions,
Right.
for example. It does not necessarily have to be when you're alone with the jurors in the jury room.
So now that could happen during
What?
the trial. You could ask that kind of a question.
Not most places, not now. You
Oh.
could. Now, you were allowed to take notes,
Yes.
Yes.
and you were allowed to take the notes with you into the,
No.
oh, you were not allowed to.
No.
No.
Yeah,
So-
until
So,
deliberation.
Judge Geller, what's the reason for that irrationality?
So they can't take the note, so they can take the notes, they take notes during trial. At the end of each day,
Oh, right.
the notebooks are collected and locked up for the evening, and then in the morning, they're redistributed in the jury box.
What's, see, that,
It's just the way-
that,
That's one of those things, it's just
that's
the way.
like an exam. Now, on everything, I could say criminal jury trials in Baltimore are not handled like a college class or a high school class, except for the fact that you can't take your notes. Why don't you allow them to
you
take
know,
notes?
it's funny. No, they take notes. They just
Yeah, but
can't.
why can't they take them? Is that a state law,
No, it's
or is
just
it practice?
it's just a practice. I don't know.
Why?
Right.
Well,
They can
We
take them into
don't.
the jury room?
we, right,
They have them during deliberations.
Oh, I'm sorry, I misunderstood.
yeah,
Deliberation.
Oh, got it.
Deliberation.
Yeah,
You
yeah.
can't take them home at the end.
right.
Right.
You can't take it
Fair.
Them into the jury room
Right, you have to
until we
leave them on the
deliberate.
seat.
until deliberation.
Now, the judge tells you, I bet he told you at the beginning of the case, stay away from the internet
Yes,
during this case. Don't be researching the lawyers or the
Yes.
defendant or
Yes.
any of the facts.
yes,
Was that, I know you all obeyed it.
yes. We
uh,
did, we
but-
did,
But was it tempting?
Absolutely.
extremely. You do not know, I have that street in my brain. It is like, and now when I pass the street, I'm like, you know what happened there? You know, because it's always in my mind, because the minute that we were done, everybody, I mean, all of us took our phone numbers, and the minute that we made a decision, we all text each other like, did you look it up? Like, we wanted to find out what was really going on, because I don't know if you remember, Judge Geller, but we ended up, everybody was crying. We just started crying at the end, and like, even the men were emotional, the women was emotional, mom was everybody. I've never felt that. I felt like I was on trial and my heart was beating, and I've never cried. It was the second time I served, but I just remember bawling because I'd been holding it all in for so long. Like, the weight of it was finally over, and I've never felt that way. I felt drained, like emotionally drained at the end, because it wasn't what I thought it would be. It wasn't how we thought we were going in there. I had a misconception that these people that I thought would think this way, they didn't think this way, and we were all in there like, really? That's how you really think? You know, like, it was amazing to me. And I kept saying, you know, I learned a lot about people. Do not judge a book by its cover, because once you get behind there, people will change, and how they personally feel really takes on a mind of its own. Because people kept referring to their own selves. Well, this has happened to me. And I was like, this isn't about you. You know, this has happened to all of us, but we have to separate that. So it was really hard, because people be like, well, this was me. And I'm like, oh my gosh, it was hard. I woke up at 3 o'clock in the morning thinking about it, crying about it, making a
Oh my
decision
goodness.
about it, thinking, what have we done? What are we doing? What am I standing for? How am I affecting these people? This is people's lives. Every day it consumed me until we finally were done. But it was life changing.
What was the charge in your case?
A lot of
Yes, if anyone in the audience has any questions,
First, yeah, you can add
holler
first
them
degree
out
murder.
to these people because they're
Yes, yes.
here. Because I won't think of them all.
Question Smith. is the one- Yeah.
Let me ask you this. Some jurisdictions around the country are sending to jurors in advance some information about the case so they can get a questionnaire filled out. I take it that's not done in Baltimore at all.
No.
But if you got such a questionnaire, wouldn't you be tempted to look up things on the internet?
Yes.
Obviously,
Yeah.
if it's
Yes.
before you, that's the disadvantage of that practice. The
Right.
temptation, even if the judge warns you in writing, when he sends you the questionnaire, there'd be a big temptation to jury instructions. Does the judge give you written instructions to take back in the jury room? Did you have a set of written instructions?
Yes. Yes.
And
Did-
actually, I'll say since I was with you in New York, I've changed my practice. So I typically would read the instructions and then give them a copy. I've now changed. I give every juror a copy of the instructions before I start reading them. And I tell them, it may seem silly that I'm reading this out loud to you. I need to make it part of the record, but you'll have this to follow. And I've noticed now in the last couple trials when I've done this, when I turn the page, everyone's page flips. People are underlining things, and I don't know if that
And they can take them back, and they get to
Everyone's-
take their
yeah,
stuff
everyone
back into the
gets-
jury room.
So every juror has a copy of instructions, one verdict sheet goes back.
Yeah.
And I think actually, my last trial, they went back to deliberate at 4:30, then they asked, can they just come back in the morning? They came back, they deliberated for 10 minutes and had a verdict.
There was an article recently in The Economist. Wasn't it, Anna, that article in The Economist about jury instructions not being written in plain English? And what was the occasion of that? Sam Shepard? It was, I don't remember what caused it, but there was an article in The Economist written for non-lawyers about the fact that one of the biggest problems of jury trials is that you're given instructions in gobbledygook. And the jury has a hard time, particularly with the reasonable doubt. I mean, they had that instruction, for example, the typical instruction written in The Economist, and it said, you know, these psycholinguists is who they call them. The psycholinguists have looked at this and they say, no wonder people have a horrible time with that instruction. And we should try to get instructions written in plain English. So during your trials you were in, did anyone ever send out any questions to the judge during deliberations?
We did.
We did.
You did?
First times, yes.
And what was the response? I hate to even ask that. I'm not going to ask.
I believe-
I don't want to ask Judge Geller.
If I'm thinking of this trial correctly, I think the question that came out several times was, we can't reach a verdict. What happens when we can't reach a verdict? We
Continue
can't
to
agree. And I write back, please continue deliberating.
Yes.
Okay.
We would be back there like, what? Or one of them, I think one of them was like, we're unanimous on some,
Oh, yeah, that really got the
But-
lawyers.
but
The
we're
lawyers
not-
loved hearing that.
but we're not unanimous on all. And then we get, please keep deliberating. We were like, duh, because we were just stuck. Like, we were, I mean, when I say stuck, I remember on that Thursday evening saying, we're not, okay, mistrial, it's just gonna have to be a mistrial. I remember coming in Friday saying, I'll be the one that does it. I'm done.
Amazing.
I have no more to give. If it's me, I'll stand up and say, I did it, I said it, I was done. And I came in to.
Were you the foreperson?
No, I came into deliberations on that Friday, and I sat there, and I said, "This is it. This is my decision. I've been up since 3. I'm exhausted. This is how I feel. I can't do this anymore." And they were like, "Yes, we agree." And 7, 8, 9, 10 of us agreed. It was the 2, and they were just dabbing at show us, show us, show us, and we kept. You know, the point that we kept getting at was. Their feelings kept coming in. And how you said, you gave a great example of the laws. Like, we kept saying, yes, these are the charges, but are they applicable to what has happened? Like, these are the charges. Well, this person's guilty of this. Yeah, he might be or she might be, but is this on this paper? And that was so hard for us to get because we might have felt they were guilty of something, But what was on that paper just did not stick. And we kept looking and looking, and I kept saying, it's the charges. It's the way that the person was charged. It wasn't so much.
Whether they did it or not.
Right, it was, and we kept fighting about that because they were like, you're guilty of something. And we were like, probably, but we can't prove it, so. And at the end, the one thing that changed that wavered was the fact that we all had to come to the agreement that this person has already served time. That's what changed the mind, was the person did time already. So they're still not innocent. They still didn't get away with it. You know what I mean? Like,
Got it.
that's what stuck, was like somebody still had to pay with time taken. And so that made it.
Depending on if this is on appeal, we might want to move on.
Okay, let me move on. At the end of the case, now, Judge Geller has said that he has, thanks to NYU workshop that he attended, now visits with his jurors at the end of the case. He tells the lawyers, you tell us what you've done.
So this is after I had the trials I had with you. I was always I was afraid to go back and talk to the jury for fear that it may have some impact on the ultimate, on something for appeal, or I just didn't want to meddle with the jury. But after hearing judges from other jurisdictions, and I was talking for a while with the judge from Denver, the head of their highest court requires every trial judge to talk to every jury after every trial. They're mandated to do it. And he explained, because when he goes back, he just tells them on the front end, I don't want to hear anything about your deliberations. What I do want to hear is, what can we do better? How can we do better? How would this have been a better experience for you? And I did that for the first time. I just finished a rape trial. And it was really, I talked with these folks for like a half hour, 40 minutes, and they had questions about the process, and they want me to get a refrigerator for the jury room. Not in the budget, but no, but it was helpful, and actually I regret that I hadn't started doing that sooner.
Do you mean before
All right.
or after
At the-
deliberation?
After the verdict is rendered.
Okay.
Okay.
You went back and talked to him.
Yep.
And
Yeah.
do you want to tell the judge anything now about your experience? That you would have
Well,
told him after the trial that he'd come back?
Well, no, he invited us to chat after the trial. We were, and I guess at the time, the judges, even though you are so friendly and so approachable, it's the nature of the bench makes one hesitate to rise to see you. I felt compelled to let the prosecutor know that he had failed and for what reasons, because I thought we had to deliberate for so long because we were afraid that we were letting someone guilty go. And because there were driving under the influence and driving while intoxicated, we didn't want to put her back on the road. But he had not proven his case, and the climate in Baltimore City, especially now, is that the word of a sworn officer is not absolutely taken against the citizen. And the officers did not use their cameras, and they did not back each other up in proving her sobriety, and she did not take the breathalyzer. So we did not have proof. It was his word against hers, and he had failed to prove her guilt to us.
Ms. Scott?
Yes.
What would you have said?
Pardon me?
What would you have told were you in the same trial?
Yes, we were.
Okay, what would you have told Judge Geller?
That he was a wonderful judge.
Okay,
I've been on several juries, and as I had told him earlier today, on one jury, the judge yelled and screamed at us after we came up with our verdict, and after our 4 or 5 hours of deliberation, did not feel that we had deliberated long enough. And as jurors, we stood there thinking, like, what the? Because we're not getting paid a lot of money, we're coming here to do our civic duty, and I don't mind doing that, but we were totally humiliated. And we just, our mouths dropped, and then when we left, it was like we were in a state of shock to be treated like that. So then, That was my last experience, and then I came to Judge Geller, and he seemed
Different.
to treat us as, with the respect that we treat him or you treat anyone else. But that's not always the case. So I wanted to be on the panel and make sure that people recognize that.
I'm
not every
president of his
judge-
fan club.
Yeah, I am.
And Mr. Reed, what would you do to change the system, if anything? You remember enough from your experience?
Oh, yeah. Sometimes I spend a lot of time on the streets in the public transports, in the jury room, and you hear things people say.
Hear what?
You hear things what people say in the jury room,
Yes.
or before or after. And sometimes it's not nice. They're sometimes dick. I know it's going to sound, I don't know how to put this, but $15. I don't care. I got all the time in the world. I find it very interesting education. But the idea of maybe letting jurors have a say, ask questions, could be very well good idea.
What?
Sometimes I sit there, in the past few I've had, with drug cases, and one with BG&E was like, I want to say something, but I can't.
Yeah.
I want to ask a question. I can't.
Okay, now, we've run out of time, but I want to give you all an opportunity to answer the same question I put to the people at my Jeffersonian dinner. If you were accused of a crime, would you want to go before a judge or a jury to decide your guilt or innocence?
I would ask for a jury.
Okay. And Ms. White,
I would ask for a jury.
Ms. Welty,
I would ask for a jury.
Ms. Scott,
Jury.
Mr. Reed.
Jury, definitely.
So we have a unanimous verdict.
I take,
And on that, thank you
I'll take
for
a,
anything.
I'll take a bench trial with Judge Friedman.
Thank you very much for coming and participating today. Thank you for sharing with us. We thank you very much. You have done something that's very valuable. You know, we live in a time where people fear that the government is going to somehow do things that are not fair with us. Everyone feels that in a way. It's impersonal, and the whole idea of juries, where they were to be the ultimate check and balance on justice in our country. I mean, they check the judges, they check the people who are appointing the judges, and they protect the average citizen. Because when you get 12 people off the street, first place, there's no way anyone can know who they're going to be. You can't bribe them, you can't influence them. You know, they are independent. It's independent, fact-finding citizens. And it couldn't be done unless people like you, who are thoughtful, are willing to do it. And then thank you very much for coming and sharing with us today. And thank you all for coming. We will distribute to you all this afternoon. After we do these things, we send out a little survey, and if completed, it takes about 3 minutes, if you will. And we'll see if there anyone here who wants to volunteer to maybe do this again next year or sometime. But I mean, if it's going to be done in Baltimore again, someone in this audience will say, I learned enough out of this to justify coming again. Judge Garbus, look who came in. Judge Garbus, could you come up here? Don't leave. Don't leave. Judge Garbus, come up here. Judge, could you say a few words to these people about the importance of jury service? And thank you for taking care of your jury.
Well, my jury just went out to deliberate, which shows you the problems with jury trials. I'm sorry I missed this great program, because Steve does a wonderful job, and I'm 100% with him.
Thank you for coming, Judge. It's great. Okay, thanks a lot. Have a great time, guys.